they pose a potential serious menace and danger to the health, safety, and morals and welfare of the people, particularly the children of Michigan. So when you tell the judge this is the intent of the act, and you can look at your client after you've had a risk assessment done, a psychosexual risk assessment, and say, Judge, this is a low-risk individual. This is somebody who had experimental sex. This is somebody who played doctor. This is not a menace or a danger to society. That can really persuade judges, and you can just take it out of what is SORA meant for, not for many of our clients. Before I get into the new laws, I want to tell you about 3 recent Court of Appeals and Michigan Supreme Court cases, and they're not, 2 of them aren't cited in my handout, so I'll give you the cites and tell you what they are. The first one is People versus Fonville, and that's and that kind of goes hand in hand with Padilla, which we're not talking about today. But in Fonville, that was the first case the Court of Appeals said it's ineffective assistance of counsel for us as defense lawyers not to tell our clients they have to register as sex offender. And the reason is because how can somebody do a knowingly and involuntary plea if they don't know the rest of their life they're going to have that label and the stigma of being a sex offender? So this is a great case. If you have any clients that weren't told that they had to be on the registry, a lot of times it's a catch-all provision where you don't even know. Nobody knows in the courtroom where you have an offense that isn't a listed offense, but it's sexual in nature with a victim under 18, they go on the registry. See if your client wants to withdraw if he wasn't told he had to register as a sex offender. And in Fonville, there is a little bit of a bad part of it, in my opinion. And I've given talks before, and I've had people say, well, she's such a defense attorney. So this is, caveat, this is all coming from a defense attorney. But in Fonville, the court held that being on the registry is not punishment. Where we have People versus DiPiazza, which contradicts that. And I think if you get that argument in court, you have to distinguish Fonville between your clients, because in DiPiazza, that was a HIDA defendant who had teenage sex. In Fonville, he didn't get HIDA, so he had a conviction. So that's a big difference. And also that it was a child enticement kidnapping case where this guy had his girlfriend's kids and he was driving around them all night and didn't return them and was high and drunk. So it's very distinguishable. So if a prosecutor argues Fonville doesn't let you have relief because SORA is not punishment, distinguish it. Now also another case I didn't put in my handout is People versus Cole, and this is unpublished. It's from 3/15/11, Court of Appeals, and the Westlaw number is 895243. This is another one that goes on the heels of Fonville. There they said it's ineffective assistance of counsel if you don't tell your client that because of a CSC2 conviction with a victim under 13, it's lifetime monitoring. So they let Cole withdraw his plea because nobody ever told him, if you plead guilty, you're going to have a tether on your leg for the rest of your life. The last case I want to talk about is People versus Lee, and this is very recent. It's from June 30th of this year. This is published Michigan Supreme Court case, and the site is 489 Mich 289. This one's very important case, and for any judges here and prosecutors, look at this case, because this case, the judge, this was a catch-all provision, and what the catch-all provision is, for those of you who don't know, if it's not a listed offense, if the charge or the offense is sexual in nature, involves somebody who's the victim's under 17, you go on the registry. And in People versus Lee, it was a child abuse third-degree case. Nobody in the courtroom, I mean, they were arguing, the prosecutor and the defense attorney, well, this doesn't fall under catch-all. Prosecutor saying, yes, it does. The judge at sentencing said, I'm going to wait. I think it was 20 months later, he had a hearing whether the defendant had to register. The Michigan Court of Appeals upheld, and he said, yes, the defendant has to register. The Michigan Court of Appeals upheld it. And surprisingly, our Michigan Supreme Court reversed and gave us a win in saying, no, a judge has to order sex offender registration before or at sentencing. Anything later doesn't count because the judge is violating the law, the SORA, which says you have to order it at the time of sentencing. And that also said the prosecutor was out of luck because the prosecutor wanted to file a motion to correct an invalid sentence. They said, it's past 6 months, you can't file it. So that person, because he wasn't ordered to register at sentencing, will never have to. So, and I also want to tell you, if anybody has questions, just find it easier, you can ask me during the presentation, so just feel free to raise your hand or call out my name if I don't see you. So I want to talk to you about now the recent changes to the Adam Walsh Act. And Adam Walsh Act is a federal statute about the sex offender registration. And you know John Walsh, who's America's Most Wanted. You know, his son was kidnapped and murdered. And he's a big proponent of the registry. And he was a big influence in getting these passed. And Michigan substantially complied with the Adam Walsh Act, because if the states don't, it's the state's decision. If they don't, they lose millions of dollars in burn grant funding. But what's interesting, there's only 7 states who have complied with the Adam Walsh Act in the whole country. California hasn't, Texas hasn't, Arizona hasn't. And the reason the majority of the states in the country hasn't done the Adam Walsh Act is because it costs a lot of money to implement it. It takes a lot of discretion from the state legislators. You have to do what they say in the Adam Walsh Act. So most of the states said, I'm not doing it. But Michigan did. And it's good and it's bad. Let me tell you about the good part of the Adam Walsh Act for our clients. Juveniles. They're the biggest victors in this. Any juvenile who has, at the time of the offense, was under 14, they automatically get removed from the registry. I mean, that was huge, and I think the prosecutor's office was in support of that. I'm not sure, but I think they were, because it just defies logic to say, how can a 10-year-old be deemed a sex offender? Their brain's not even fully formed. That's another argument I make in these cases, is that the frontal lobe that is in all of us is not fully developed until we're mid-20s, and the frontal lobe is so important for our decision making, for risk-taking behavior. That's why we look at teenagers and go, what are you doing that for? Because they don't have that part of the brain which makes them say, stop, don't do that. That's important to point out to judges when you've got a teenager doing, group sex or having a one-night stand or getting really drunk or high, saying, Judge, here's how a person develops. So juveniles under 14 do not have to register. And if you have any, what you can do, and let me give you this phone number. Karen Johnson is the person who is the manager of the sex offender unit. And she has been, in my experience, very helpful, very efficient, and very quick in correcting things. And her phone number is 517-241-1839, and her fax is 517-241-1868. So if you have a client who says, hey, I was 10 years old at the time of my offense, I'm still listed on the registry, what you need to do is to get documents from the court to support that, to show that at the time of the offense, not at the time of the plea or the conviction, but how old was he or she when she was involved in the incident. And send it. You can fax it to Karen Johnson. She'll review it, and if she can support that, she will automatically take it off. You don't have to go to court and file a petition. For some reason, Karen Johnson won't take the juvenile off the registry, then you file a motion, a petition in the sentencing court to show it and get a judge's order. Then also, it's important to keep Sharon Johnson's phone number, because whenever you get an order for removal, send it up to Ms. Johnson. She will make sure, I've seen her, she's about a day or two now, turnaround time, that your client will be taken off the registry.
Cheryl?
Yes.
Is that both the public and the non-public?
Yes. Yep. Because that's a good point. All juveniles under the Adam Walsh Act are non-public. So sometimes it's a little tricky to say, well, I don't know if you're on the registry because we can't look. If we look up on that website, we don't know. So call Karen Johnson and say, I just want to verify if this person's on the registry. He's a juvenile, I can't tell.
She is Michigan State Police?
Yes, she's Michigan State Police. And also for juveniles, so you got the juveniles who are 14 to 16. They do not have to register, even on the non-public registry, if it's a Tier 1 or 2 offense. If it's a Tier 3 offense, they have to register for life, and it is non-public. So anytime you have a juvenile, it's always going to be non-public, but I'll talk in a little bit. That helps a little bit for people, but it's still a really hard life to be on the non-public sex offender registry. HIDA, the other good news, HIDA still doesn't have to register. Romeo and Juliet cases where you've got teenagers having consensual sex. Even if, there's some judges who don't give HIDA. We're lucky in Wayne County, we have judges who understand the importance of HIDA, but in some other countries around the state, they are by policy, they just don't give HIDA. So even for the 18-year-old having sex with his 15-year-old girlfriend, he's got to register on the sex offender registry. Now, so the legislature said, that's not fair. Let's give them a way to come off the registry. So what you do is a hearing before sentencing to prove it was consensual, that the victim was between 13 and 15, and there's not more than 4 years age difference between the parties. Now, the not more than 4 years age difference, I'm sure that's going to, I'm waiting for a case to appeal that, because I think it's Michigan State Police's view that that means it has to be 48 months or less. My view, why aren't they letting, if the legislative intent is to give relief to those Romeo and Juliet offenders, why can't they be 4.5 years age difference? And I think about with charging for CSC cases, if you have a victim between 13 and 15, well, if the victim is 15 and a half, they still charge it as 13 to 15. So why isn't the relief under the registry the same? And but argue those. If you get a client calling and say, and I've had a couple of them already call me, I'm 4 years and a week age difference, I'm still going to file them and battle it out in appellate court. Also, Tier 1 is private, so anybody, not even, if it's an adult, Tier 1 is private, non-public. They still are under all the duties, and they have to do everything the law says, but they're not listed on the website. And homeless, I really like this change, because how many times were we having cases about sex offenders who are homeless saying you failed to register? And the new law, it says the residence is the city where the person spends the majority of his or her time. So your homeless clients who are registered sex offenders only have to put the city down. And that is going to clear up a lot of headaches we've had in the past. Okay, for the bad news, we now have lifetime registration for a lot of people, including CSC3 teenagers having sex, unless you can get HIDA or prove in a Romeo and Juliet hearing before the sentencing. They have to register for their entire lifetime. There is much more required by registrants, and I'll go over that in a little bit, but they have to give up almost every part of their life now. There is also increased penalties for failing to verify. They have to, depending on what tier you're on, you have to go once. Oh, okay. You either have to go 1 time, 2 times, or 4 times a year to go verify your address, and you only have a 15-day period. If you fail to do that, and I know police departments who say, you're 2 days late, so sorry, I'm going to write up a police report and charge you. That is now a 4-year felony offense. It used to be a misdemeanor. Now it's 4 years they're looking at. Failure to change your information, you have 3 days now under the new law. If you have a new address, a new email, a new employer, new vehicle, you have to go to the police department in your city, the registrants do, change that within 3 days. If they don't, the first violation is a 4-year felony, the second violation is a 7-year felony, and the third violation is a 10-year felony. So, I mean, it's a lot, and I can't tell you how many people, because they're teenagers, or they're just not organized, they forget to go and do their period verification. So you have people who aren't willfully or intentionally failing to verify, but it happens, and they're now looking at a really serious felony on their record. So I'm not, in my handout on page 2, they have down what is convicted for SORA purposes, and I listed it all out. Having a judgment of